Our next guest, Christina Teixeira. And Christina, please correct me if I'm butchering your name. Uh, Christina is the daughter and granddaughter of Portuguese immigrants. She earned degrees in political science and women's studies from San Francisco State University and her law degree from Dale E. Fowler School of Law. After working with California Rural Legal Assistant, she joined state service and currently serves on the Civil Rights Department's outreach and education. So without further ado, Christina, the floor is yours.
Thanks so much. I'm feel very privileged, very lucky to be here today. I'm Christina Teixeira. I use she, her pronouns. I'm an attorney at the Civil Rights Department, and I'm also the co-chair of our DAC. I'm middle-aged, I'm Portuguese, I have olive skin, I have long brown curly hair, I'm wearing black glasses, red lipstick, and a sort of maroon colored blouse with leaves on it. So I'm here to talk to you about the Civil Rights Department. Because I'm a lawyer, I will start with the lawyerly disclaimer that we are not making any law or policies today. This is all information, and it is all incumbent upon all of us to stay aware of changing guidance and laws. So a little bit about the Civil Rights Department. Our mission is to protect the people of California from unlawful discrimination in employment, housing, and public accommodations, and from hate violence and human trafficking. You may be familiar with us under our previous name, the Department of Fair Employment and Housing. We changed our name just about 2 years ago next month, because as you can see from our mission, we do so much more than just housing and employment. So just to round that out a little bit, some more about our responsibilities at the Civil Rights Department. Probably what most folks know us for is investigating complaints of discrimination and other civil rights violations. I'll talk in just a moment about the different sorts of laws that we enforce. And certainly when someone files a complaint with us, we try to facilitate resolution of the dispute, right? We have a whole division of mediators who try to help folks work it out. But if they can't, we also can prosecute violations in civil court. Now, we don't always do that. You can imagine how difficult that would be with a department of just about 350 folks. Our department also helps to issue regulations to provide greater clarity regarding laws that we enforce. Statutes are the laws that the legislature develops, and then regulations kind of explain what those statutes mean. If you've ever looked at the law, you can see that those statutes are pretty short, right? What does that mean? How do we interpret that? That's where regulations come in. Certainly, that's also where case law comes in. We also collect data on pay and demographics of large employers' workforces. You'll see that pay demographic data come out in a few months. We do what I'm doing now, which is to conduct outreach and training to inform folks about their rights and obligations under civil rights laws in California. And we have a very unique unit in our department that is somewhat new, and they work with communities and state and local bodies to constructively resolve and manage conflict that has a community-wide impact and that's rooted in discrimination. That's a lot of stuff. Let's talk a little bit more about the types of laws that we enforce, and hopefully that can provide a little bit more context for what we do. So we enforce the Fair Employment and Housing Act, or FEHA, which Bobby mentioned a little bit earlier, and sort of talking about the application of laws. And FEHA is going to apply to all of us. It protects employees and job applicants from discrimination and harassment on the basis of protected characteristics. That includes disability, genetic information, medical condition. It also covers age, which, as we age, we may develop infirmities, right? Our eyesight might get worse. I'm wearing glasses now, right? And this, like I said, FEHA applies to state and local government employers and also private employers with 5 or more employees. An important caveat there for FEHA, 5 typically is the magic number there, right? Someone's got to have 5 employees or more for all of these protections to kick in. But in regard to harassment, There is no sort of threshold. It is illegal for employers of any size to harass their employees on the basis of a protected characteristic. We also enforce the Equal Pay Act, which I mentioned a little bit earlier in terms of collecting pay data for large employers. We also enforce some other laws that are sort of outside of the scope of employment, what we're talking about with the DAC, but I want to make sure to talk about these and lift these up because we don't take off our disabilities when we leave work, right? We may be subject to discrimination or harassment in myriad other areas of our lives. So it's important to lift up these as well. One is the UNRRA Civil Rights Act, which prohibits discrimination in businesses, right, places of public accommodation. For folks who are familiar with the Americans with Disabilities Act or the ADA, the UNRRA Act incorporates the ADA. So all of those ADA provisions that you are aware of exist in UNRRA. The Ralph Civil Rights Act, it protects individuals from hate violence or threats of violence based on their protected characteristics, which again includes disability. We also enforce the Disabled Persons Act, which provides equal access to public places for folks with disabilities. I mentioned human trafficking earlier as well. We do have authority to enforce some human trafficking related laws. We also can provide certification for folks who have experienced human trafficking and who cooperate with our investigations or complaints related to human trafficking. We can help provide certification for those folks to try to get legal status. And lastly, also relevant to us as folks who work for state government, we have authority to enforce Government Code Section 11135. That's sort of California's general non-discrimination statute. And again, applies to folks with disabilities, protects us from discrimination by recipients of state funding. Or any kind of state financial assistance. So if there's an after-school program that gets any piece of state money, any state dollars, they can't discriminate under 11135. So really important to be aware of that. I mentioned in the chat earlier too that depending on the type of funding that a healthcare provider receives, they may be subject to 11135, right? Thinking about Medi-Cal, thinking about folks that that might receive, well, and I should be specific there about Medi-Cal, certainly because Medi-Cal also extends to undocumented folks. So be a little bit thoughtful, you know, in terms of who you're filing for and what the purpose is there. Now, our ability to do any of this as the Civil Rights Department is contingent upon us meeting folks where they are. And so for that reason, we provide, I'm sure as you folks do, accessible services for folks with disabilities to participate in any part of the Civil Rights Department process. So we've got a particular unit that addresses those things. We have emails and then particular phone numbers that will lead to the ability to request an accommodation in a more expedited way. Now, we're the Civil Rights Department, so obviously, you know, we acknowledge the importance of civil rights, and certainly disability rights is part of that. Now, I know in a manner of speaking, I'm preaching to the choir because we are here because we know and we understand that disability rights are so important. But I wanted to lift up just a couple of, and I do a training that's very similar to this. Once a month or so, and so it's important to me always to give context for why we are talking about these things. Why is this important? And we can see here that most Californians with a disability work, but they work at a lower rate than folks without disabilities. And we're looking at something like almost 30% of the entire population of the United States has a disability. That's 1 in 4 folks. Think about people that you work with. 1 in 4 of those folks, right, has a disability. You can see here on the right-hand side that there is a bit of a breakdown that comes from the Public Policy Institute of California regarding the different types of disabilities that folks experience. So you can see there that the most represented is related to cognition, to concentrating, remembering, or making decisions. So those may be largely invisible disabilities. Again, why is this so important? Disability is the most represented protected basis in our employment complaints. I believe it's also the most represented protected basis in housing. This has been true for many, many years at the Civil Rights Department. And I didn't want to provide you the whole list. We're very fortunate in California. We have a giant, list of protected bases, much more robust than the federal government or some other states. But I wanted to give you the top 6 here so that you could see disability is first, retaliation is second, right? Now that could be retaliation for, requesting an accommodation. But also we have a whole separate category because it is so significant for folks who requested or used a disability accommodation and experienced discrimination as a result. And then I just mentioned age, right? And as we age, sometimes we do develop disabilities. You can see age breaks the top 6 as well. All of this information comes from CRD's 2023 annual report, which you can find online. It's also linked herein. So when I provide this, if you're super interested, you can go ahead and take a look. Something that we encounter a lot in regard to reasonable accommodations in particular is concerns about the cost of an accommodation, right? Well, what's it gonna cost, right? And does that sort of open the floodgates? Can we accept? Can we even consider myriad sort of multiple accommodations? Two things about that. One, the average accommodation is free, and this information comes from JAN, the Job Accommodation Network. And secondly, that sort of floodgate analysis, right? Well, I'm going to open the floodgates, and then everybody is going to ask, and I won't actually be able to respond to all of those. That's actually a prohibited type of analysis. The law says you cannot consider a future hypothetical reasonable accommodation request in addressing and dealing with an immediate real request that's in front of you. And Director Rutledge talked about, really emphasized the importance of an individualized assessment. That very much is part of this sort of calculus. You can see too, though, that there are costs sometimes, but $300 a one-time cost, right? Maybe that's the purchase of equipment, maybe that's the purchase of software, that won't need updating. So important stuff to think about and consider. And something too to say in regard to state government or really any employer, when an employer thinks about and considers whether or not providing a reasonable accommodation is going to be an undue burden, they have to consider all of the resources that they have available. So that would mean all of the financial resources that they would have available to be able to accommodate folks. Now, I was a legal services attorney for 8 years. I worked at CDSS for about 5 years, auditing county welfare departments in the civil rights unit. And now I'm at the Civil Rights Department. So I've seen a lot of reasonable accommodation complaints. And I've seen a lot of areas where the reasonable accommodation process tends to break down. So I wanted to just uplift some of those before I get into the CRD complaint process and resources that we have available for folks. Where things can tend to break down, at least in my experience, and this list was developed in collaboration with partners from the EEOC. So this is also reflective of what they see at the federal level. The process is unreasonably slow. And it's important to note here that an undue delay in providing an accommodation, that means initiating the process, not necessarily giving someone the accommodation they're asking for, but initiating that process can be disability discrimination. An immediate no, we don't do that here. No, that's not an accommodation we provide. Without engagement in the interactive process, that's very likely going to be disability discrimination, just right off the top. So something that I talk to HR folks about, I talk to employers about, is the time to be aware of your reasonable accommodation process is not after someone requests a reasonable accommodation, because then you are exposing yourself to liability. The time to be aware of those things is before, right? Be proactive, invest the time and the education in folks, not just maybe your reasonable accommodation unit, not just, your one designated reasonable accommodation coordinator, because folks can make accommodation requests to their managers, to anyone who sort of represents their employer in a managerial or supervisory capacity. So those folks are very much, they need to be on notice. They need to be able to identify and sort of clock accommodation requests when they come in, because failing to acknowledge that request and initiate the appropriate process can be disability discrimination in and of itself. Another area where the process tends to break down is that it's sort of unreasonably burdensome. Something to think about here in particular is medical documentation or proof, essentially, of a disability. I've definitely seen employers request proof or supporting documentation of a person's need for an accommodation when the disability is obvious. That is unreasonably burdensome, and it's contrary to the law. So if someone, for example, who uses a wheelchair asks for a sit-stand desk, or a desk that moves, right, so that they can adjust it based on their wheelchair height, or if a person with a prosthetic hand asks for speech to text technology for typing, it would be inappropriate in both of those circumstances to request or require that that person provide documentation of their disability and the related need, right? We can see very clearly, very plainly what the connection is. And the stronger the connection between the disability and the requested accommodation, we call that the nexus. The stronger the nexus, sometimes that leads into less documentation, less support being needed. Not always, particularly when it's related to invisible disabilities, because employers absolutely can request proof. I think that came up in the comments, how sort of difficult that can be for the employee, which is why I wanted to lift up this particular issue about being unreasonably burdensome. Some employers also sort of get caught up in what's an essential task of the job versus what's a marginal task of the job. Reasonable accommodations, right? Folks have to be able to do, with or without an accommodation, the essential tasks of the job. But marginal tasks can sometimes be reassigned, right? Can sometimes be moved. Sort of relatedly, right, confusing essential, and Director Rutledge spoke to this as well, sort of confusing, essential functions with, how a person without a disability does the job. Director Rutledge said, I've done my job, I just do it in a different way, right? And so employers can't necessarily dictate how a person does that job if they're getting the job done appropriately. Documentation of reasonable accommodations also can be an issue. For getting reassignment, it's what's there, but I think generally just not providing that continuity of a reasonable accommodation. We know that sometimes in state service, there is a lot of turnover in management. And when managers are vested with the authority when they're the ones who are responsible for making sure that there's continuity of accommodations for folks, and there isn't a good structure for documentation, confidential documentation, or sharing that information, then there can be a gap in the reasonable accommodation that's provided, and that may very well also be disability discrimination, right? That means that the person then has to come back and make the request again, and maybe go through that same burdensome process, which again, we saw and heard in the chat that it very much tends to be a burdensome process. Sometimes employers also, they sort of prioritize health and safety concerns above reasonable accommodations. That sometimes can be the case. There are some exceptions in regard to disability accommodations about things like a direct threat. But at the same time, being a direct threat, finding that someone is a direct threat does not alleviate the requirement to engage in the interactive process. All roads lead to the interactive process. Yes, interactive process. No, interactive process to figure out something that works. Health and safety conditions that we have to address and deal with, interactive process. Yes, I gave you an accommodation, interactive process to see if it still works, right? So keeping that line of communication open is incredibly important and is sometimes where this breaks down. Sometimes also multiple requests, sort of arbitrary terms in the requests, right? You feel like maybe folks are they're moving the goalpost, so you can't quite get your arms around the accommodation that you need. And related to that is, sort of drawing unnecessary lines in the sand, which is that sort of floodgate kind of argument too, right? Well, I can't possibly accommodate you because then I'll have to do it for everybody. Yes, the answer is yes. Sometimes that's going to be the case, but an individualized assessment is required for each one. So employers are not sort of locked in to providing particular accommodations as a matter of course necessarily, because they have to go through that individualized assessment. That speaks to and recognizes how, as people with disabilities, we have intersecting identities, and sometimes our disabilities interact differently within our bodies. And so it's really important not to paint with too broad a brush. Now, in our last 5 minutes or so together, I want to talk a little bit about our complaint process. You can see some of the highlights here from our 2023 annual report. We secured over 116 million in relief for folks, and we were able to enact a wide range of policy changes. I mentioned that we try really hard to settle complaints through conciliation or mediation. You can see that those numbers are there as well. And again, we're a department like complete, like boot to bonnet, we're 350 people. So when we say we do 5,700 investigations, that's a pretty small team that's doing it. And they work really hard and they're really thoughtful about how they approach issues. There's a lot of internal conversation about forecasting, trying to identify trends so that we can be responsive and things of that nature. I'm gonna flash this flowchart on the screen. I'm not gonna go through it. I know it's a bit much, but it is the whole employment process. I will provide these slides to Bobby so you can spend some time with this at your leisure if that's the kind of thing you like to do. But you can see that it's a pretty robust process. I'll say too that statutorily we are supposed to complete our initial investigations within, I believe, 100 days. Sometimes we're not able to meet that again, right? We're a super busy department, not a huge department, but we make sure that we keep folks informed every step of the way. So some possible complaint outcomes, if you do file a complaint with the Civil Rights Department, that's within our authority, within our jurisdiction. Think back to those laws that I rolled through at the top of our time together. So some possible complaint outcomes could be being reimbursed for actual losses, maybe compensation for things like emotional distress. And this is broader, right? So if a person's been, denied housing or something of that nature, they might be granted access to that denied housing. If they were not hired or if they were terminated, they could maybe be hired back or reinstated, receive back pay or promotions that were wrongfully denied. Also, we can, and something that we do particularly in settlements, is we want to make sure that we are providing a sort of affirmative training obligations, right? Like we want folks to not just comply because they got in trouble once, but we want them to really learn about the process and implement those appropriate policy changes, not so that they, no, not just so that they can avoid liability in the future, but so that they can provide a better workplace for folks, a more inclusive workplace. There are plenty of studies. I know that there was one in the Harvard Business Journal about how diversity actually makes workplaces better, more profitable, have better ideas, better implementation, right? Because of that diversity of viewpoint. Certainly also, if we go to court, there are sometimes civil penalties or punitive damages. Those are required by law. And then also attorney's fees and costs if CRD represents somebody and prevails. The first step in this process, however, is filing an intake with us. Not every intake becomes a complaint. We have folks that will assess the intake form for jurisdiction, i.e. authority. Do we have the authority to take this on? Do we enforce those kinds of laws? So there are lots of different ways of doing that. Folks with accommodations can contact us separately if they need a particular accommodation for filing an intake form. We also have an online portal or good old, snail mail. If anyone still has a fax machine, we'll take it that way. Folks can also file with us by phone. And I want to insert a caveat here that, state employees really should first raise and address issues with their department EEO folks to learn the full scope of their complaint or appeal options. Because I'm just speaking from the Civil Rights Department perspective. There are certainly other avenues and options that I am not the expert to speak on. It's great to be here with you all. It's wonderful, but we're all going to leave this meeting and you may want or need resources beyond this. So I wanted to take just a very quick trip through CRD's resources. We have a ton of written resources online. We have a whole publications section. We have one that's dedicated to employment, but then we also have one dedicated to protected bases. So if you want to look particularly for disability-related information that's outside of employment, you can also look for that there. I mentioned that I give a training kind of like this. We do, here's a listing of them. CRD does webinars, myself and my colleague, twice a month, and we alternate between housing, employment, and a special topic. So I just gave a training I gave a training last week on employment rights of LGBTQ folks, and my colleague gave a training yesterday on housing rights. She'll be doing that again in July regarding housing rights of people with disabilities. She and I will be presenting together on protections for transgender people in California, which will include employment. And then I will be giving 2 training sessions on employment discrimination 101 and legal protections for workers with disabilities. They're an hour long. They're at 11 a.m. They're always on Wednesdays. If you can't join us for live webinars, or that's maybe just not your thing, we also record our webinars without audience participation because we want to encourage candor in those spaces. You can access information on our YouTube and sort of listen to it in the background, or skip ahead to the part that's relevant to you. And that is my time. So I will stop here and turn it back over to Bobby and Alex.
Thank you so much. Really, it's very informative and helpful. Would you be able to share your slides with us? There's been some requests.
Yeah, absolutely. Yeah, I need to, I wanted to add a couple of things recently.
Yeah.
So I do need to have it remediated.
Yeah, that's fine.
Yeah,
convenient.
I'll have it remediated and then send it over. Because we want to make sure that this is really accessible to folks. There's some good evergreen information in here.
Yeah, thank you. Very helpful. One of the questions I asked the previous guest in a very inarticulate way, and that is the distinction between the FEHA, ADA, and the governor's executive order that refers to the 4-day return to office. Can you just briefly tell us the distinction?
Yeah. This is a question that the Civil Rights Department has been getting a lot recently. And I think part of that is because of executive orders also at the federal level and then federal law evolving. So certainly folks have questions for us. It comes up pretty often. It's a little bit of a civics lesson. So what I'll start by saying is that the federal law creates the floor of rights, the absolute minimum amount of rights we find at the federal level. What that means is that states can build upon that and provide more rights. They can't provide less. So I mentioned that, we're very fortunate in California. We have a lot of different protected bases that don't exist at the federal level. That's because the federal level's the floor, and we've built upon it, right? We're not giving less rights. We're not taking protected bases away, but we are adding protected bases. So there sort of is there is a bit of a difference in terms of authority. Obviously, state law, even if it builds upon the floor, has to comply with the floor, right? We can't sort of diverge from those things. State statutes, state regulations, typically, right, the same way that state law has to comply with federal law, even when additional protections are built up, executive orders at the state level are the same. So any kind of executive order that comes out has to comply with the law. It can't diverge from the law or take people's rights away. It can build upon it, but it has to conform with the law. So essentially what that means is that people can still request reasonable accommodations, even when an executive order says return to work. That it doesn't mean that the ADA goes away. It doesn't mean that the FEHA goes away, but it does mean that that executive order, right, does have to work together with those things. I mean, I think that I don't think that that's wildly controversial, right? Just the fact of how this works, and what's subject to what, but I know it can be a bit confusing, and I won't get into the weeds on the interpretation of all of those things, but certainly an executive order cannot create less rights or take rights away from folks.
Thank you so much. I really appreciate you clarifying that. Yes, you're right. It's not controversial and it shouldn't be that complicated, but a lot of department view the mandate as being overarching regulation that perhaps is a requirement, that 4-day return to office is a requirement, and somehow there's a less distinction between that and the FEHA and the ADA and reasonable accommodation for that matter. And that's all I was trying to clarify. So thank you for expressing in a much more articulate way and as a lawyer.
Oh, I don't know about that, but I appreciate I appreciate your generosity.
We do have Alex. Go ahead and ask your question.
Thanks. First, I'm going to ask a question, then I'll ask somebody else's question, which I have a related experience with. So the first question was with regards to what we just finished discussing a second ago. So the executive order, and I believe Bobby was talking about it a bit ago, it mentions that the agency shall consider employees' requests for more than one telework day per week on a case-by-case basis as required by, I'm sure you're familiar with that bullet by this time, since we're months from when this was issued. So while you were saying the floor is by the federal and then state has their own state rights. So this is recognizing, and this is me just speaking out loud, and maybe I'm not saying it correctly. So this is giving the ability for agencies to provide case-by-case exceptions to the 4-day in-office portion of the executive order as applicable to meeting FEHA or ADA or any other applicable disability-related rights.
Yes, but I think I would take it a little bit of issue with the term exception, right? That it's an exception to this requirement, right? Because a reasonable accommodation, if we're just going to define it, is any kind of modification to the workplace that enables a person with disabilities to perform the essential functions of their job. And so it's not so much an exception from the rules, it's just a modification of the rules. But the important part there is that it has to be disability related. And I mentioned a little bit about the supporting documentation, right? And the nexus, that is all part of this conversation as well. I think essentially the executive order says, like, this executive order complies with the law. We can't tell you what the outcome is going to be. We can't tell you what the ADA would require, what the FEHA would require, right? Because it's a highly, highly individualized assessment, and is going to be up to each particular employer's abilities, right? Their administrative abilities, their financial abilities. And so I think that's really just what the executive order is saying is this is what's required, but we still do comply with the law. And if folks do have, they have legal rights under the ADA, under FEHA, those have to be considered by their individual departments.
Okay, thank you.
Yeah, absolutely.
And thanks for the clarification. I'll start using the word modification instead of exception when I say that. No, I appreciate that. I really appreciate that. I think
Occupational hazard.
Thank you. I appreciate that. And then the question that was asked in the chat about the as applicable to burdensome process. Do you have ideas on how the process can be improved when a person moves positions between departments? They state, to their knowledge, an employee has to redo the RA ergo process at each department, and that seems burdensome. Why can't requests equipment move with them? And then I can tie it to myself as an example. When I was at one agency, I just finished having an experience where I was receiving reasonable accommodation equipment, and then I was transferring to a whole other agency. So they were still receiving my reasonable accommodation equipment towards the end of when I was going to be there. And then the new agency had to reacquire the exact same equipment. And so it was being purchased twice. So I believe as a taxpayer and ratepayer that that was a complete waste of money. So I don't know if there is a better or standard process that can be followed.
It's a great question. Unfortunately, sort of, outside of the scope of what CRD does, it's a question. So I was a hiring manager in the state as well, and have had those sorts of questions come up. I think, there are reasons why there are those rules, right? The individualized assessment, each individual employer being able or not being able to provide, right? Their own ability to sort of, not self-determination, but their own ability to engage in that interactive and individualized assessment to look at what their own abilities are. I mean, that's part of the reasoning as far as I understand in the rules. CalHR might be better suited to speak to this because maybe there are very good and valid, reasons in addition to that individualized assessment why that's not a practice. But I also think that, departments having equipment, more equipment than they had when a person started might not be a bad thing in terms of having an inventory. I mean, obviously it presents an issue for the person who's moving, but Director Rutledge also, I think, spoke to interim accommodations. So that, there certainly can be those interim accommodations. And I see that there's some chatter in the chat about the flow chart. And my apologies that I did not walk through the whole thing. I will tell you, it is a bit unwieldy. It's not my favorite representation of the complaint process, which is why I roll through it pretty quickly. But it is accessible. And so when I provide it, you'll be able to listen along to the process, even though, again, not my favorite. Not my favorite way that we describe that.
Great. One question that's posted here: when my reasonable accommodation was not being handled professionally by the HR and my HR was not respecting the ADA laws, I file a civil rights complaint with my department and then went with the FEHA. Where does the state civil rights department sit in this process? Because I was under the impression the process was first the Department of Civil Rights Unit, then the federal government. And I'm sure you could answer this.
Yeah, and I again, like I say lovingly, I'm an attorney. I'm not anyone on this call's attorney, so I can't provide legal advice. And having been a lawyer, I know that every situation is far more complicated and nuanced than it looks on the surface. So I just want to acknowledge that I don't want to provide, incorrect or inappropriate information. But what I can say about the process, and this is a place where folks do sometimes experience some confusion, is that there's no sort of like step up process to get to the federal government. If you want to file directly with the EEOC, person can do that. The reason, though, that I spent some time talking about the difference in protected bases is because we have more protected bases in California than they have at the federal level. And so let's say you have a complaint based on disability in gender expression. Gender expression is not covered by the EEOC. So if you wanted to file that particular complaint, you would want to file that complaint with the Civil Rights Department or with the California, someone that recognizes that other protected basis. We also have a dual filing agreement with the EEOC, so sometimes we end up with EEOC cases. Same thing with HUD, with housing, right? We have an agreement with them, and sometimes those get dual filed and we end up with them. So there's no sort of, no sort of step up process necessarily. If you want to go directly to the federal government, you can. If you want to go to CRD, you can. I did mention though that folks should really talk to their internal EEO folks first to find the full scope of their options if something like that has sort of gone sideways. Which also apologies for the frustrating experience.
Any other questions for Christina?
Thank you, Carrie, in the chat for mentioning that. Yes, thank you also for mentioning that there are some distinctions. The bar in California, it's a little easier to pass. At the federal level, to be a qualified person with a disability, you have to have a physical or mental impairment that substantially limits your major life activities, whereas in California, the standard is limits. You have to have a physical or mental impairment that limits your major life activity. So it's an easier standard to meet. Thank you for pointing that out, Carrie.
Great.
Awesome.
Anything else that we have Christina can answer on behalf of this wonderful audience?
A general question, maybe this ties to the flow chart and the floodgate type logic. So in immediate, no, we don't do that. My understanding is that it's a likely type of disability discrimination. So what recourse does someone have if this is experienced as far as process? And I ask that because I know of an agency that was drafting RA policy in the past, and in the draft, it didn't make it to the final, but they were adding things into their RA policy, much of which were actually acceptable types of reasonable accommodations. So I'm curious.
Yeah, no, I appreciate that question. I mean, case law supports the notion that an immediate no, we don't do that here. End of discussion. Here's a list of accommodations we don't provide, we'll never provide. I think that's a dangerous place to be because of that highly individualized assessment. And certainly case law supports the notion that an immediate no without engaging in the interactive process is disability discrimination. I recall reading a case that the interactive process took 2 years. A woman had she had a scent sensitivity and brought that up to her workplace, and it took 2 years to figure it out and resolve it. And the court found that that was not disability discrimination because the employer engaged in the interactive process and documented their engagement over that 2-year period. So really engaging in that process, even when you're unsure, is the best way to serve folks with disabilities in a thoughtful, meaningful, and appropriate way, and then also a good way to avoid liability.
Carrie made a point here. She says, forgive my forwardness, but isn't that immediate no is what's happening currently with telework?
Well, no, I think because of the bullet point that Alex read out, that's in the executive order.
Right.
I believe maybe they are getting to the point where many agencies are being silent on that part of the executive order. They're stating other parts, but they're often enough staying silent. I'm trying to be nice, staying silent on that portion of how they're interpreting it to their staff.
Yeah, and the most important thing is that when folks with disabilities request accommodations, that those be discussed and handled appropriately, right? All we can do is ask and start that process, but then that process does have to be carried through. But each individual department has to perform that individualized assessment. And again, that nexus. Why do you need to work from home, right? Try your best to articulate and strengthen that nexus. That's the connection between the disability and the accommodation, the disability-related need. So, that's the best you can do when you're, a person with a disability trying to explain or request particular accommodations.
And if some department is saying that we will not grant telework, we don't do that because of the mandate, then that would be, an immediate no, correct?
I think in the response to that would be, hey, the executive order, says that these are all subject to the ADA and to disability, related accommodations. And hey, I'm an individual with a disability that requires an accommodation for telework. Here's why. Here's my support. Let's talk about it. And the answer may be no. Right. The answer ultimately may be no, depending on the individual circumstances. But the important part is the process.
Right.
If there's no process, if there's no discussion, then you have no recourse other than to, try to pursue your rights another way.
And if they just say immediately no, because that's our policy,
that's a problem.
Responds to the mandate, then that's a problem. Correct?
That's a problem for any employer.
Yeah.
Any employer, anywhere.
Right. True.
Yeah.
That's all we were trying. Well, thank you so much.
You're very welcome. I'm again very, very pleased to be able to be here with you. Feel very privileged to be among you folks. Thank you for inviting the Civil Rights Department, and let me know if I can be of further support.
Absolutely. Come back and visit us anytime. We always welcome your wealth of knowledge. Been fantastic presentation. Thank you, Chris.
Thank you.